Good afternoon, everyone. Happy November 4th. Welcome again. If you've been here for multiple Lunch and Learn seminars, welcome back. If this is your first time, nice to meet you. My name is Peter Neufeld. I am a partner at Wagner Sidlowski, and I'm the co-chair of this Lunch and Learn series with uh, my partner, Brad Phillips. The umbrella title of this Lunch and Learn series is called Strategies, Advice, and the Elderly. And the specific subtopic that we're going to be talking about today is guardianship applications. It's a broad topic, so this will be a very much an overview, but we hope you appreciate it and get something out of it. A paper was prepared by Charles Wagner and Adine Wagner in advance of today's seminar. And a PDF copy of that paper can be found in the Zoom chat. Maddie will be adding that to the chat. Thank you for doing that. The certificate of attendance will also be posted in the chat momentarily for you to download. Make sure you download anything you want before you leave the Zoom call today because you can't log back in and download it if you forget. This seminar has also been approved by LawPro for the Risk Management Credit Program, and it's eligible for a $50 credit claim, so you might as well take advantage of that. Thank you to our sponsors, as always, Scotia Wealth Management, the B'nai B'rith, Concentra Trust, Weir Folds, Donovan Kochman, and Torkin Mains. This event is complimentary because of them. As always, a few housekeeping notes. Please have your microphones muted at all times. Your videos are automatically on when you log in, so please turn them off if you don't want us to see you. Again, with respect to microphones, have it muted unless you're going to be asking a question, then you can unmute yourself. And when you're done asking the question, please go back to mute. Please also know that this seminar is being recorded. You may have heard that at the beginning of me talking today. We have two presenters today, James Dunphy and Adine Wagner. James Dunphy is a partner at Wagner Sidlowski. He is practicing in both the estate and commercial litigation groups, and he will be here as well with Adine Wagner, who's an associate at Wagner Sidlowski, also practicing in the estate and commercial litigation groups. We also have Cheryl Landy here today from the B'nai B'rith, and she's going to talk a little bit about the organization and some of the programs that they offer. So Cheryl, go ahead, take it away.
Thanks, Peter. I hope everyone can hear me. It's a pleasure to be here. My name is Cheryl Landy, and I have the privilege of serving as the Director of Community Engagement at B'nai B'rith Canada. Excuse me. For nearly 2 decades, B'nai B'rith Canada has proudly partnered with Wagner Sidlowski's CLE programs. We're deeply grateful for this long-standing friendship and for the meaning contributions your firm continues to make within the legal community. Your support has allowed us to continue the work we care so deeply about, work that changes lives every single day. As many of you may know, B'nai B'rith Canada is the country's oldest human rights organization. We're dedicated to fighting racism and hatred in all its forms, advocating for the Jewish community, and supporting some of Canada's most vulnerable individuals, our seniors, living in poverty and people who often find themselves isolated or alone. When people ask me what B'nai B'rith does, I tell them we defend, we care, and we lead. Over the years, I've had the joy of sharing stories about our food bank, our affordable housing program for seniors, both lifelines for those who would otherwise be left behind. I've told you about our clothing giveaway program, which brings warmth, dignity, and joy to hundreds of families, and our men's program, which builds connection within the community. And of course, on our last call, I shared the story of Tuna Tuesdays, a simple but powerful initiative where students from a local middle school collect cans of tuna for our food bank. This small act of kindness from a younger generation helps feed families across the city. It's proof that compassion doesn't depend on age or wealth, just an open heart and good intentions. Today, I'd like to share something new and very close to my heart, our women's group. Originally, our women's group came together to learn and connect through monthly speakers. But before long, they wanted to do more. They wanted to create programs that made real, tangible difference. That's how our Tuna Tuesday was born. And now we've launched another inspiring initiative. This one created to empower women new to Canada. We'll be partnering with employment and newcomer agencies to assist women who are looking for work, women who may be new to Canada, rebuilding their lives, or simply trying to regain their footing after a challenging few years. As we all know, COVID changed the world. It isolated us and reshaped how we work and live. Many women transitioned from working from home and have since found their closets are filled with clothes and shoes they no longer need, items that have symbolized opportunity and professionalism now unused. This new program will give those items a second life and provide women with a second chance. We'll be collecting gently used clothing to keep them out of landfills and secondhand stores. And instead of offering them directly to women in need, and instead we will be offering them to women in need, those preparing for job interviews or stepping into new careers. But we're not stopping there. We're creating a full training and empowerment program. Participants will receive not only free professional clothing, but also guidance and on resume writing, interview tips, and computer and language training. All the support they need to face the open job market with confidence and dignity. Our incredible volunteers will visit clothing factories and retail stores to collect donations of overstock and gently used items, ensuring every woman who comes through our doors leaves feeling strong, capable, and beautiful. Here's how it will work. Agencies will refer clients to us, and our volunteers will meet one-on-one with them, pairing them with the right clothing and providing personalized support. Every conversation, every fitting, every resume review will be done with empathy. This program will be volunteer-led and volunteer-run, embodying what we at B'nai B'rith believe in most, people helping people. Because at B'nai B'rith, we don't just believe in giving handouts. We believe in building people up, in creating experiences that empower, uplift, and remind everyone, young or old, that they are seen, valued, and loved. Thank you again for welcoming me here today, for your continued support of B'nai B'rith. I look forward to sharing more of our stories in the months ahead, stories of kindness, resilience, and hope. If you'd like us to help us continue this work, please visit bnaibrith.ca/donate. Your generosity helps us provide not just clothing or food, but compassion, connection, and hope. From all of us at B'nai B'rith, thank you for standing with us. Together, we're not only changing lives, we're building a stronger and healthier Canada. Thank you for your time.
Thanks very much, Cheryl. And in addition to the link that Cheryl referenced, Maddie will be posting a link into the Zoom chat if you wish to make a donation. So thank you again. Let's get on with the main part of the presentation. Again, this is about guardianship applications. Adine Wagner will be starting off.
Thanks, Peter. A guardian for property or person is someone appointed to make certain decisions on another person's behalf. A substitute decision maker, in other words. And the Substitute Decisions Act is the legislative Bible for this topic. So, of course, the SDA will be at the core of our discussion today. And as Peter mentioned, we are here today to talk about guardianship applications, the court proceeding to have someone appointed as a guardian of property or person. And specifically, I'm going to take our audience through who can bring these types of applications, the steps that those people need to take, and the factors that courts are to consider before appointing a guardian. But before I get into those specifics, I think it's important to start with what the goals are here, a mission statement for these types of application, which Justice Brown helpfully provides for us in Abrams and Abrams. Justice Brown writes that guardianship litigation has only one focus: the assessment of the capacity and best interests of the person whose condition is an issue. His Honor also goes on helpfully to specifically highlight what the court is unconcerned with. Quote, "This court, as the master of its own process and as the body responsible for protecting the interests of the vulnerable identified by the legislature in the SDA, should not and will not tolerate family factions trying to twist SDA proceedings into arenas in which they can throw darts at each other and squabble over irrelevant side issues." So as always, what to avoid and what to keep in mind are always to be a priority for any lawyer acting with respect to these applications. Now, going into who can be appointed as a guardian. If a potential client comes into your office seeking to be appointed as a guardian of property and or person for an incapable person, they have two hurdles to clear. The first one is, are they eligible? And the second one, once they are found to be eligible, is, are they the appropriate choice to be appointed as guardian? The eligibility hurdle is actually quite low because Section 22 of the SDA permits, quote, any person to apply. But despite that broad category, there are restrictions, and certain individuals are prohibited under Section 24 of the Act. One is a person who provides healthcare or residential, social, training, or support services to an incapable person, unless they are that incapable person's spouse, partner, or relative. And the second is a non-resident who shall not be appointed unless the person provides a security approved by the court. But once an eligible person to be appointed does apply, the question becomes, who is the right choice? And to help the courts answer that question, the SDA provides a set of criteria. And it's important to remember, especially when we reduce the question to a set of criteria, the animating purpose of this determination is the best interests of the person whose condition is at issue. And not only will courts hearken back to this point when they're in doubt, but it will also serve as the foundation of their analysis under the different criteria. And naturally, one of the simplest ways to gain an understanding of what is in a person's best interest is to look at that person's decisions. Who do they trust? Who are the people that they surround themselves with? What do they want? The SDA places a premium on the incapable person's personal choices. And in deciding whether or not to appoint someone as a guardian, courts are to look at A, whether the proposed guardian is the attorney under a continuing power of attorney for property, i.e., has the incapable person already made the decision to appoint someone? B, the current wishes of the incapable person, if they can be ascertained. And C, the closeness of the relationship between the applicant and the incapable person. And if the applicant is not the proposed guardian, which is sometimes the case, the court is to look at the closeness of the relationship between the proposed guardian and the incapable person. Now, it's important to mention that all of what I have just said applies if and only if the person whose condition is an issue is actually incapable. Because the key legislative policy underlying the SDA is to protect the autonomy of all persons of age to make their own decisions. Capacity is presumed. A guardian for property or personal care will only be appointed if there is a finding of incapacity made in relation to such decisions. And this is no small thing. This can be seen in the very strong language used by Justice Myers in Fisher and Danalunas, which helps emphasize this point. His Honor explains that Section 25 of the Substitute Decisions Act brings home the importance of a finding of incapacity before an individual's autonomy over her property is displaced. I note the language displaced. He writes further that judges must make express findings that someone is incapable of managing their property prior to appointing a guardian who will be empowered to do so in their place. But the key excerpt from Justice Myers' reasons in my opinion, is this, quote, "This is one of very few statutes in which a legislature has required that judges show their work. They must prove by their words that before making a decision, they have considered the legislative criteria. The statute demands that judges show that they have properly balanced individual autonomy against the need for care of the vulnerable person as reflected in the very definition of incapacity." So in practice, the requirement under Section 25 of the SDA means that every application to appoint a guardian must include a requisition for a declaration of incapacity. And of course, that declaration may be opposed by the allegedly incapable person, because you may find that someone alleged to be incapable is incredibly resistant to the idea that someone else ought to make decisions for them. And I believe that James, in the second part of this discussion, is going to go into a few details on the difficulties of litigating this issue, along with the court's reluctance to order capacity assessments. But while I'm on the topic of the interests and autonomy of the person whose condition is an issue, I will note that the appointment of a guardian is just one of the tools available to the court to protect the allegedly incapable person. Courts may instead decide to appoint Section 3 counsel, because sometimes a court will want to avoid infringing on the privacy of the person whose condition is an issue, and the court will refuse to order a capacity assessment in those cases. This will obviously deprive the litigation of any proof of incapacity, but the court still may decide that the person whose condition is an issue must be protected within the context of litigation in some way. And in such cases, they can appoint Section 3 counsel to act as the lawyer for the person whose condition is an issue. But I will emphasize that the role of Section 3 counsel is distinct, and it is not to act in the best interests of their client or what they believe to be the best interests of their client. Because Section 3 counsel is not that person's guardian. They are their lawyer. And the job is therefore to seek out and take instructions from the person whose condition is an issue. Now, with that background, I want to go through some of the procedural requirements for guardianship applications, and through that, some of the issues that may arise as applicants try to navigate our system made up of rules and discretion. Service of your materials is always something to keep top of mind, because there are often a lot of parties with some connection to these types of applications, all with varying degrees of involvement. Section 69, sub 1 through 4 of the SDA mandates who must be served personally with the notice of application and accompanying documents. Those parties are the person alleged to be incapable of managing property, the attorney under the continuing power of attorney, if known, the current guardian of person, if known, the current attorney for personal care, if known, the public guardian and trustee, and the proposed guardian. Service on the family of the allegedly incapable person is mandatory as well. The family may be served by mail, though, as long as they are not part of any of the personal service categories that I had just gone through. And the family members, which is laid out in Section 69, sub 6, would include the spouse or partner of the person who is alleged to be incapable, the person's children who are at least 18 years old, or in the case of an application or motion under Part 1, at least 16 years old. Sorry, in case of an application or motion under Part 2. Third would be the person's parents. Fourth would be the person's brothers and sisters who have attained the relevant age referred to in paragraph 2. But I want to go back to personal service, and specifically the service on the allegedly incapable person. When arranging for service on that allegedly incapable person, there is a question that tends to come up quite a bit, which is, why are we serving someone personally when they are not able to understand or appreciate the nature of the proceeding? And our response to clients who often are worried about upsetting their allegedly incapable parents with this type of application is that the SDA presumes capacity. And the legislature and courts are very zealous in protecting the personal autonomy and rights of those alleged to be incapable. And speaking of those courts, some case law is going to help me demonstrate how these service obligations are dealt with in practice. And as we go through the case law, you will note that the degrees of flexibility or rigidity, which with the courts address the procedural requirements of guardianship applications, point back to the underlying ideas that we've already discussed. What is in the capacitated person's best interest? Respect for the autonomy of those alleged to be incapable. And who can the court rely on to ensure that things are done the right way? I'm going to start with the case of D'Amico and D'Amico, which deals with many of the issues that we've been discussing, but from a bit of an awkward angle, which, as lawyers know, creates some interesting case law. In this case, the sisters of an incapable person applied to be and were appointed as the guardians. But the sister's lawyer did not deliver the notice of application to family members, despite his statutory obligation to do so. The family members therefore brought an application to set aside the guardianship that had been granted. And this application brought by the family members was resolved on consent. But while the case, which was eventually resolved on consent, was ongoing, the family members who brought the application racked up over $70,000 in legal fees. And then those family members tried to recover some of those costs in an interesting roundabout way. They applied to the court to have the Public Guardian and Trustee, the PGT, pay a portion of their legal fees. And they argued that the PGT's failure to ensure that they received notice caused them to incur the costs of the application. The court did not agree. It found that the PGT has no statutory obligation to police proper servants by the applicant, and that the PGT did not act in bad faith in this circumstance. But the case does raise the question as to what if the cost award had been sought against the applicants who did have the obligation of proper service rather than the PGT. In another case, Said and Ontario, Office of the Public Guardian and Trustee, the court deals with how to balance their deference for the presumption of capacity as well as the procedural requirements. And it's an example of how the court's deference for that presumption of capacity informs how rigid they can be with their emphasis and enforcement of the procedural requirements. So this case was a guardianship application that was severely lacking. The required management plan and guardianship plan that make up part of the application materials were omitted. And the applicant also did not serve the allegedly incapable person. The court set aside the application for its failure to comply with its service and documentary obligations. And at paragraph 4, the decision judge noted that the SDA provides that the allegedly incapable person is to be served with a notice of application to appoint a guardian of property, and that the proposed guardian here sought to be relieved of this obligation. But the judge quoted Brian Schnur and stated that it does not appear that the court is permitted to dispense with such service under the SDA. But with all that said, there are cases where the court did dispense with the requirement to serve the incapacitated person. And these are instances where there was evidence before the court about the capacity and the lack of capacity of the allegedly incapacitated person. In O'Connor and Mulville, the court relied on evidence of the incapable person's physician to dispense with the requirement of service to the incapable person, finding that the individual was not capable of understanding any legal documents. In Jansen and Jansen, an individual who had suffered a severe brain incident which left them in a vegetative state was the subject of 2 competing applications for guardianship of the person by his wife and by his sister. On the procedural side, the presiding judge ordered that the requirement of service in Section 69 of the SDA was to be dispensed with. But what about service on individuals who do have capacity, like family members? Boyd and Thompson is a case where the court showed some flexibility on that front. In Boyd, a woman suffered brain trauma and her husband applied to be her guardian. The husband notified the women's parents of the process, but he did not formally serve them, and the parents consented to the husband's appointment. Nevertheless, the PGT objected to the husband's appointment and argued that the statute's use of the phrase, quote, shall serve, meant that service on the family was mandatory and could not be dispensed with even on consent. The court ended up siding with the husband, and it held that the entitlement to service also included a right to waive such service as the parents did here. But the question remains, what if those upon whom service was mandated did not waive service? Would the judge have set aside the application? Overall, the case law appears mixed on whether the failure to serve in accordance with the SDA can void the application ab initio. And when dealing with mixed case law, our recommendation is always going to be some version of the same type of advice, which is to dot your I's and cross your T's. Discretion is a fickle thing, and it is better to comply with your statutory obligations for service and documents to be included in the application than it is to rely on the generosity of the court to save your application with its discretion. And with that, I'll hand it off to James.
Great. Thank you very much, Adine. Hello, everybody. So what I'd like to talk a bit today about is probably the most consequential documents that you would prepare in an application for guardianship. So that's your management plan and your guardianship plan. And they're consequential for a couple of reasons. During the application itself, these plans will be used to determine whether or not you are suitable to be the applicant. And that will be based on your proposal for how to manage the incapable person's property and manage their personal care. And if that management or guardianship plan is approved, then this will be the guiding document for the guardian in the performance of their duties. And it will form the basis of any subsequent scrutiny of the decisions made by the guardians. And that subsequent scrutiny could come from the Public Guardian and Trustee, the court if asked, or even potentially a beneficiary of the incapable person's estate. So a management plan. A management plan is used to set out what your plan is to deal with an incapable person's property. And where can I find it? Well, it's called Form 2, and you can access it through the Ontario Court Forms website. And it's quite an intuitive form. It's really prepared with a view towards a lay person being able to understand and complete it. It consists of 14 parts, parts A to N. And the majority of it deals with specific types of property assets, the liabilities, income, expenses of the incapable person. So you have headings like land, general household items, valuables, savings, securities, business interests, stuff like that. And what you're required to do under each of those headings is you must give the particulars of what those assets or income or liabilities or expenses are. And you give an estimated amount. And, the estimated amount is interesting because it's not asking for an exact amount. Often the guardian will not have access to all of the information necessary to calculate what the assets are. But they're required to give a plan. And that's a plan for how you propose to deal with the incapable person's assets. And, plans are, by their very nature, inherently fact-specific. There is not a one plan fits all. Perhaps the only thing you could say that's common across all applications is that the applicant must carefully consider what the incapable person's required expenditures are. And not only today, but in the future as well. And that will differ in every case. And, it's the Substitute Decisions Act tells you what required expenditures you must make. And before I get to that, it's helpful to have, a couple of scenarios in your mind to to apply these required expenditures to. So, consider on the one hand, let's say a 50-year-old incapable woman with a net worth of $30 million. She's a divorced mother of 4 minor children, and she has 2 financially dependent parents. So contrast that scenario with, say, a 92-year-old gentleman with no dependents and whose sole asset is a small rural home. So what required expenditures does the Act tell you to make? So that's set out in Section 37 of the Substitute Decisions Act, and they fall under 3 categories. So 37 says that a guardian of property shall make the following expenditures from the incapable person's property. Number 1, the expenditures that are reasonably necessary for the person's support, education, and care. That makes complete sense. Number 2, the expenditures that are reasonably necessary for the support, education, and care of the person's dependents. That's number 2. Number 3 is the expenditures that are necessary to satisfy the person's other legal obligations. So, and there is a hierarchy there, which we'll get to in a moment, but, compare the 50-year-old incapable woman with that high net worth who is a divorced mother of 4 children. Point 1 says that you must pay, the guardian of property shall make the expenditures necessary for her support, education, and care. Then number 2, the guardian shall make the expenditures necessary for the support, education, and care of the person's dependents. Now, I gave an example of 2 different types of dependents. They were her minor kids and her dependent adults. So the guardian would have to engage in a weighing exercise and make a reasonable and rational decision as to how to appropriate the funds in that case. And the third category is the expenditures necessary to satisfy that woman's other legal obligations. So I mentioned that she was a divorced mother. Perhaps she might have a separation agreement. There might be a divorce agreement. And obviously those agreements give rise to legal obligations. And is the guardian required to pay out pursuant to those agreements? Well, the legislation says yes, so long as there's insufficient funds after categories 1 and 2 are paid. And the Substitute Decisions Act gives guiding principles to the guardian when exercising their authority under this section. So the guardian must look at the value of the incapable person's property, their accustomed standard of living, must have regard to the dependents and the nature of any other legal obligations they have. And it expressly says expenditures under paragraph 2 can only be made if paragraph 1 is satisfied. Expenditures under paragraph 3, that is other legal obligations, they can only be made if the property is enough to satisfy the obligations under paragraphs 1 and paragraphs 2. So every case turns on its own facts. Every case is inherently fact specific. So if you're asking why can't the Substitute Decisions Act provide a little bit more guidance, it's because it can't. All it can do, the best it can do, is give that overarching guidance. So the guardian, as you can probably tell, may be required to make very difficult decisions. The guardian may have to decide if the incapable person can continue to reside in their home alone, or if they need to be relocated to a retirement home. These are difficult decisions. Sometimes the incapable person simply cannot afford to stay in their home. They may need to have their home retrofitted. They may need to have 24-hour nursing care. They may need to hire additional staff. And these costs, they pile up. Anybody who's been involved in the care of an elderly person with extensive needs will know how quickly those costs rack up. So it's up to the guardian to determine if the incapable person has sufficient liquid assets and to liquidate assets if necessary to meet those expenses. Now, in the management plan, there is also a section called legal proceedings. And legal proceedings, the applicant is required to set out what are the legal proceedings, not including the guardianship application, but any other legal proceedings that the incapable person is a party to. And very often, as lawyers, you'll get a call from a personal injury law firm. They're bringing a personal injury suit on behalf of an unfortunately now incapable person, very often the victim of a catastrophic injury. And that is the type of litigation that one must list in the Guardian or in the management plan. Very often these types of personal injury actions will result in a significant award in 1, 2, 3, 5 years down the road. And it's very common that you will have an interim plan up until the point that this matter settles, the action settles. And there will often be a requirement, often built into the order, that the amended management plan be prepared and served once the personal injury action settles. And the final part of the management plan is it underscores the duty of the guardian to consult with the incapable person. So Adine has gone into details and the court's view on why the views of the incapable person are so enshrined in Ontario and Canadian law. There's also a duty set out in the Substitute Decisions Act to seek to consult with supportive family members and friends. There's also in the management plan, it expressly sets out the duty of the guardian to determine if there is a will. Because as you know, Section 35 of the Substitute Decisions Act says that a guardian of property shall not dispose of property that the guardian knows is subject to a specific testamentary gift in the incapable person's will. Of course, that does not apply to a specific gift of money. And at all times, these testamentary gifts are subject to the care and support of the incapable person. So ascertaining the assets of an incapable person, how do you do it? Well, sometimes it's easier than other times. And what compounds the job of the guardian is that, they very often have no legal basis to compel the production of financial information. If they're a joint account holder on that person's banking, that might be easier. But very often, you get clients that say, I understand that he has money in A, B, and C, but, I believe that they have additional funds. I don't know where. We've approached the banks. They won't give us any information. We're not the guardian. We're not the attorney. So, it comes back to the estimated assets that's required by the management plan. And if the estimated assets, or you believe that the estimated assets is not complete, after you get the guardianship order, it may even be built into the judgment. You will have to come back and file an amended management plan once you get a better idea of what the incapable person's assets are. And if you're wondering, how do I go about finding out where all the incapable person's assets are, then there is a pretty practical list contained in a blog that was written by both Charles and Greg. It's called A Power of Attorney Primer, and I think there's a link to it in the paper. So I'd encourage you to take that out and look at it. And it gives a very practical list of tasks that you can do, which will hopefully illustrate the complete value of the incapable person's assets. It's things like, speak to their professional advisors, locate and reference bank documents, look at their computers, passwords, do a title search, review their tax returns, which can give a lot of information. Safety deposit box, get an inventory, speak to family and friends, look at their debts, bills, insurance, mortgage, that sort of thing. Okay, so, sometimes guardianship applications are rather unopposed. Sometimes they're contested. And very often applicants in a contested guardianship application will have zero visibility as to what the incapable person's assets are. Now, the Substitute Decisions Act does contain a couple of sections where parties to an application may seek directions from the court. And directions in the context of a guardianship application can obviously be sought by the guardian themselves or an attorney under continuing power of attorney. But the SDA says that a dependent may also seek directions, the PGT, or any other person with leave of the court. So it's open to an applicant who is not a guardian, who is not an attorney, to seek directions from the court and ask for orders permitting them to take up bank statements, that sort of thing. But contested applications typically will involve the passing of accounts, so such directions are often not required. In the guardianship plan, which is called Form 3, you have to do a similar exercise. And there are 4 sections in the guardianship plan. And perhaps the biggest sections is sections 2 and 3, where you set out the areas where personal care decision-making is sought. So personal care decision-making falls under 6 headings: healthcare, nutrition, shelter, clothing, hygiene, and safety. And is it possible to have the capacity to make decisions in respect of your healthcare and not have the capacity to make decisions in respect of your hygiene? Yes. So it's important to have a finding by a capacity assessor under each specific heading, depending on where the applicant is seeking decision-making authority. So in the guardianship plan, typically what the guardian will be required to do, the applicant for guardianship, is set out what the current status of the incapable person is with respect to each of those 6 headings. Set out what the wishes or instructions are of the incapable person with respect to each heading. Any wishes for how that person wanted their healthcare to be provided, where they wanted to live. What the long-term goals, or what the applicant's long-term goals are to safeguard the incapable person's interests under these headings, and what the steps they will take in order to protect those. If the incapable person's needs are more complex, the applicant may need to consider obtaining a life care plan. And this will be a planner with experience in assessing the needs of incapable persons or elderly incapable persons, and devising a plan for how best the applicant can satisfy their obligations under all of those headings. The plan will also talk about issues such as employment, education, training, recreational, social, cultural activities, and social and support services. And finally, the plan includes what is set out in the legislation in any event, but such is the importance. It requires that the applicant consult with the incapable person, as well as supportive family members and friends. Okay, so I want to talk a little bit about capacity assessments. Adine touched on the importance that Canadians and Canadian public policy ascribes to an individual's autonomy. And that can come into, that can clash with the requirement in the Substitute Decisions Act that any applicant for a guardianship order also produce a capacity assessment, a finding that the person is incapable. And this is required both under property and personal care. So if that individual refuses to have a capacity assessment, what do you do? So the Act provides a mechanism to allow a party to compel another to be assessed for capacity. But the case law is quite clear that judges will rely on these sections as a last resort. In fact, the individual's autonomy is even enshrined in the Substitute Decisions Act, Section 78. An assessor shall not perform an assessment if the person refuses to be assessed. Now, Adine referred to the Abrams decision, and I'm going to refer to it as well, because Justice Strachey's comments are routinely co-opted in subsequent rulings. And His Honour said, a court must balance the affected party's fundamental rights against a court's duty to protect the vulnerable. The appointment of an assessor to conduct what is essentially a psychiatric examination is a substantial intervention into the privacy and security of the individual. His Honour quotes Justice Batillo in Flynn v. Flynn and says, a capacity assessment is an intrusive and demeaning process. And there are other comments in the Act which show that the disregarding the autonomy of the individual should not be done lightly. Sections 22 and 55 say the court must not appoint a guardian if it is satisfied that the need for decisions can be made by an alternative course of action, one that is less restrictive of the person's decision-making rights. And Justice Strady again in Kister said, the courts must resist the ability to say, I'll order a capacity assessment because it can't hurt. He specifically denounced that practice. So when will a court consider compelling a capacity assessment? So in Abrams, Justice Strady set out some factors a court will consider. The court will look at the nature and circumstances of the proceeding. He says the person's capacity must be an issue and there must be reasonable grounds to believe they're incapable. The court will look at the nature and quality of the evidence before the court as to their vulnerability. The court will take into account the previous assessment, whether it was comprehensive and the conclusions reached, whether there are flaws in that report, whether the assessment is necessary to decide an issue before the court, whether any harm will be done if an assessment does not take place, and whether there's any urgency to the assessment. And finally, and this is important, the wishes of the person sought to be examined, taking into account his or her capacity. So proceeding to court to compel a person to undergo a capacity assessment is for sure an uphill battle. It must be the venue of last resort, and there must not be other less intrusive ways of best providing for the incapable person's care. So with that, we're on about 9 minutes left in the presentation. I'll end it there and I'll hand it back over to Peter.
Thank you, James. Thank you, Adine, for that. That was very, very informative, very helpful. I'll open it up to the floor now for any of the attendees that have questions. I mean, I do have one question. This was a great presentation and very comprehensive, but it sounds pretty difficult. And the sense I get is that being a guardian is a bit of a thankless job. Can't a client just decide that they're going to let the PGT take care of it, and the public guardian and trustee, they could be the guardian, and they don't have to deal with going through the rigmarole of bringing this application and preparing, a management and guardianship plan and consulting with supportive family members and friends?
I can answer that one.
Thank you.
Having the PGT appointed as the guardian is possible, and there is a way to do it under the Act, but it's not necessarily practical in all circumstances, because the PGT is a public good, and with that comes a finite amount of resources. And the court, the legislation, and the PGT, there's an emphasis that the PGT is a last resort in those types of circumstances. And if anyone else is a viable candidate to take on the job, that is most likely going to be preferred. And the Act is quite clear that the court will not appoint a PGT as a guardian unless the application itself proposes the PGT as the guardian. The PGT consents to their appointment, and there's no other suitable person. And then in certain circumstances, the PGT, if there is a genuine risk of serious adverse effects to the allegedly incapable person, the PGT can apply to assume temporary guardianship on those grounds. But the overall point is that, yes, it's a thankless job. Yes, it can be difficult, but it is not necessarily the best option to just rely on the public good, that is the PGT, to assume the role, and you may face resistance in having the PGT appointed.
Thanks for that, Adine. I do see a question. There's a few questions in the chat, so I'll ask the first one. Um, this is a question about serving the family members. So I think it's under section 69 sub 6. There has to be service on the family members of the guardianship application. Sorry if I got that provision wrong. But in any case, the question is about waivers of service. Have either of you prepared waivers of service from family members, just confirming that they don't need to be served? I mean, in my experience, just because it is by ordinary mail, I just send it out by mail, and the job should be done at that point. Have you two had a different approach?
Yes. So, I mean, I've had family members say, I don't need to. But first of all, I would have provided the materials to the family member via email. And, I've had a case where the family member said, I don't need to be served with the materials. It is set out in the legislation that you shall serve these family members by ordinary mail. I've never brought a case where I've served the family members by email, but I don't believe that if you came to court and you had served one or two family members by email and not regular mail, and you had received confirmation of receipt, I don't believe you're going to receive too much of a hard time from members of the estates list. But it is a requirement that it be served via ordinary mail. But if there is a particular difficulty or a particular cost or expense to that, serving via email, but you're making sure that you have the consent of the person to receive it by email. You must acknowledge to the person that there's a requirement that this be sent by ordinary mail. And at the very least, you should have the family member, acknowledge all of those requirements, acknowledge that they're waiving all of those requirements, and receive it via email. If they're going to the trouble of preparing a complete waiver, it would make sense to just serve it via email and come armed to court with that information. But first stop, serve in accordance with the Act.
Thanks, James. We've got a few other questions here. One, this is an interesting one. Would a court prefer to appoint a guardian who is located in another city over the PGT? So when a court is considering whether to appoint this applicant, but the incapable person lives in Toronto and the applicant lives in, Ottawa, let's say, over the PGT that has a presence in Toronto, which angle should they, would the court prefer to appoint the PGT in that case? My gut instinct is no. Now, if they live outside of Ontario, there's requirements to post security, but I think that as long as the management and guardianship plan sort of explained how the personal care and property would be managed and that's reasonable, then I think that the court would still probably side with the applicant as long as there's no other other concerns. Did you guys have any other thoughts into that?
Sure. I mean, the bond is the issue. I mean, it depends, first of all, on the value of the incapable person's assets. If they've got very little assets, a bond is going to set you back at the very least, in around $1,500. And then depending on the premium that they apply each year. So does the incapable person have the funds to pay that? Will it unnecessarily deplete them? I mean, if that's not an issue, I guess you have the practical issue of how does an out-of-province guardian manage the property of the incapable person on a day-to-day basis?
So I think in this case, it wasn't out of province. It was just out of city.
Oh, out of city?
Mm-hmm.
Oh, so in Ontario, obviously you're not you don't have any bonding issues then. But I guess there's, you still have the practical issues over, day-to-day management of the person's property. If it's just funds sitting in a bank account and they have their, duty to act as a prudent investor, then, I can see that being adequately satisfied by an out-of-city guardian. But if the property requires day-to-day management and, oversight, and the incapable person requires, an in-person monitor, then it becomes trickier.
We've got great questions today, by the way. We've got another interesting question here about the practicalities of broaching the issue of personal service on the alleged incapable person. So how do you broach that topic? You're going to have to tell your client that, their mother or father, who, at least in your client's view, has absolutely zero capacity. You're going to need to arrange for a process server to come by and to serve them. They may think that that is a waste of time and money, and they might have some, personal concerns about that. I'll chime in because I seem to be doing that a lot right now. My pitch is always, well, you need to serve them before you get to a judge, because one of the first things the judge is going to ask me is, has the incapable person received notice and been served with these materials? And if I say, no, they haven't, then there's a good chance that this judge isn't going to grant me anything unless I've got so much overwhelming evidence to show that this person clearly lacks capacity. So it's a practical issue that, if we don't provide notice to the incapable person of this application, then in all likelihood, the judge isn't going to give us what we want on that date that we've booked 6 months in advance. Do you guys have any different thoughts on that?
No, I mean, I've that comes up quite a bit, and quite naturally, there's a concern of serving a record on an incapable person. But I mean, as you said, you don't want to arrive in court, and when the judge is performing their tick box exercise, making sure that all the service requirements have been completed, you don't want to be in a position that all of these technical requirements have not been satisfied. So service can be affected by the applicant if the incapable person is in their care. So the applicant should be counseled to serve in a manner that will best protect the incapable person and not unduly concern them. That's always my advice.
All right, great. Thank you so much for that. I see it's 1:02. I want to be conscious of everyone's time. Sorry for those that raised questions that we couldn't get to. But thank you, everyone, for attending today's seminar. Just a reminder, the certificate of attendance is found in the chat. Thank you again to James and Nadine. That was an excellent presentation. And we're looking forward to seeing everybody at our next seminar. That will be our last seminar. It is a big topic. It is on elder abuse. I encourage you to find the time to make it. We will have some excellent presenters. We will have Brad Phillips, Marshall Swadron of Swadron and Associates, and Graham Webb, who leads the organization, the ACE, dealing with the elderly. So if you haven't registered yet for that program, I strongly encourage you to do that. And then as a final reminder, the link to the B'nai B'rith Canada can also be found in the chat in case you would like to make a donation. That's it. Thank you again. Enjoy the rest of your Tuesday, everybody.